Okay, welcome everyone. I'm Joanne Lynn. I'm the Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. And welcome to our virtual briefing, which is going to be a rollout of our new 2024 strategic plan, which was approved and adopted by the Washington Lawyers Committee Board of Directors in June. I'm delighted to be here with all of you today. I'd like to introduce my colleagues who are here on Zoom with me. I'm joined by our legal director, Ryan Downer, whom you will hear from shortly. Our development director, Melissa Nussbaum, who you will also hear from today, as well as our development manager, Megan Luckenbaugh. In addition, Avis Buchanan is with us today. She is a member of the Washington Lawyers Committee Executive Committee. She was also a co-lead on our strategic planning process. There was a group of 6 board members who co-led the process, and Avis will tell you more about that. And Avis also many years ago was a staff attorney and legal director of the Washington Lawyers Committee. So she has one of those unique experiences of being both on staff and on the board. So as you can tell from our group today, we have people assembled who've been with the Washington Lawyers Committee from its inception over 50 years ago to people who are brand new to us. And that truly is, I think, one of the strengths of the Washington Lawyers Committee, that we're a mix of people old and new with a variety of backgrounds and perspectives. And all of that was factored into the strategic planning process. Let me give you a quick preview of what we're going to cover today. Avis Buchanan is going to open us up with the background and the process underlying the strategic planning process. Ryan Downer, our legal director, will then do an overview of the substantive scope of the strategic plan, the chief programmatic areas that the Washington Lawyers Committee is going to be investing our resources and time in. I will highlight some of the unique features in the 2024 strategic plan that are different from prior strategic plans. And then Melissa Nussbaum, our development director, will be closing it off. This is a very informal webinar, so we encourage people to write out your questions in the chat as we go. And as each section concludes, we can then take up those questions. But you all have access to the written chat. And then at the end of the presentations, there will be an opportunity for Q&A and oral discussion. Okay, so with that, I'm going to turn it over to Avis. Thank you, Avis.
Thank you. Good afternoon, everyone. It's a pleasure to have you here. And I also want to thank the Meyer Foundation for its support of the Lawyers Committee, Washington Lawyers Committee. As a board member, I feel it's very important. I recognize the importance of the support from a variety of sources to help the office achieve its goals and its mission. So thank you for attending this session. I want to also talk a little bit about the history of the committee and in addition to the strategic planning process and effort. The Lawyers Committee, Washington Lawyers Committee, there's a National Lawyers Committee, as most of you, or if not all of you, already know. But the Washington Lawyers Committee was started in 1968, and it was all part of the response to President Kennedy's call to the private bar to address civil rights issues in their communities. And it's always been reliant on volunteers and law firms because that's the mission. It's fairly unique in that way of approaching litigation, civil rights issues, advocacy, et cetera. And we've had a history of key accomplishments in litigation. Early on, the Lawyers Committee took on race issues and sued various agencies of the federal government. It's an alphabet soup: the FBI, all the different departments, and we sued. The Lawyers Committee brought not only individual cases but class action lawsuits, and as a result, achieved not only impact in the DC area but beyond, because these cases had national importance and were national models. We did race, gender, disability, public education. These were expansions over the course of the years. Public accommodation cases, did housing, employment, dealt with DC public schools, and in all of this was very conscious of helping those who are underrepresented and those who, and primarily race issues, but not exclusively. We pioneered testing. There was a pre-existing belief in or practice of testing in housing cases, and the Lawyers Committee transported those testing concepts into the employment arena, which was very precedent setting, and especially because there were housing issues that were barriers to or practices in the housing testing arena that were barriers to the employment testing. So we had to adapt that to make it an effective tool for combating race discrimination and other kinds of discrimination in the employment context. So we've always been relying on volunteers, as I said before, and the committee's been a very small organization historically, but has leveraged that by working with the key law firms. I came in 1969 because of the Lawyers Committee's mission, and 13 years I was there just showed me over and over again why I made the right choice. It has accomplished so much, and the quality of the work has always been outstanding. I've learned so much from partnering with firms and and we're part of these relationships that the Lawyers Committee developed over time with the volunteers like Rabbi Khan, Karen Grise. They've been important contributors over the years. So when Joanne joined the Lawyers Committee, the Lawyers Committee had been around for a while, and there was a long-term director, Rod Boggs, who had retired, and then there was Jonathan Smith. And then Joanne came, and she brought a new energy and new insight into the committee. And as a result, she had the idea that we needed to update the strategic plan, the last one of which had been done in 2017. So she created a committee. As she told you, I was a co-chair with and with 5 other people, where I was a co-chair. And we set up a process for gathering information and getting feedback. We tapped into all of the stakeholders who support the Lawyers Committee or are involved in the Washington Lawyers Committee's work. There were board focus groups. We did interviews. We worked with a consultant, the Rabin Group, who helped organize us. We worked on the fast track. Joanne set a deadline for us, and we thought if we pushed really hard, we could meet that, and we did. We had the interviews. We did a survey. We surveyed clients. We surveyed our stakeholders, the other nonprofit groups, public interest groups in the area, and other supporters like foundations, because we wanted to get an idea of what the Lawyers Committee needs to be doing right now. What are the current challenges and what are the current needs? And out of that process came this strategic plan, which has already been for which we've already begun implementation. It was voted on in June 2024 by the board. No objections whatsoever, because we had been bringing them along in the process, getting their feedback, getting their input, staff input. There was a co-operating or contemporaneously operating staff group. We met with them, and they also worked on their own track, and their input was also included in the process and is reflected in the ultimate product. So we have started already implementing the plan. One of the key components of the plan is emphasis on combating racial oppression primarily in the DC area, still using some of the same tools historically, but not as reliant on some of them. There's planning for a different kind of mix of the tools and our reliance on the tools. And one very key component is the decision-making rubric for taking cases. It's the first time that the Lawyers Committee has ever had something like that. Before, there was a kind of an informal or loose process. Not that it wasn't rigorous, but it was opaque. And so the law firms didn't necessarily know, the staff didn't necessarily know what it would take to do a case and why we might be doing a case. And it was those decisions were made on a case-by-case basis, literally. So as a result of the decision-making rubric, there's a lot more transparency about how cases can and should support the Lawyers Committee and how the Lawyers Committee should support the work and the mission. So we're really excited about that. We feel like it's very forward-looking and very useful going forward for not only the committee, but for the people who work with the committee. And so I will now turn it over to Ryan to talk about current work.
Thank you, Avis. With the adoption of the strategic plan, our core identity remains essentially unchanged. We're still a civil rights organization focusing our work on the DMV, primarily in DC. And our mission is to create legal, economic, and social equity primarily through litigation, but also through community education and public policy advocacy. The strategic plan really doubles down on litigation as our primary tool. And as Avis said, we're focused on the central role that race discrimination plays in sustaining inequity and on combating systems that sustain racial oppression. And we think that we do this best when we're led by client priorities and are partnered with organizers and community members. You'll often hear WLC staff talk about a vision of shared leadership, a model of shared leadership. What does that actually mean? And it really goes back to our roots as a committee of public interest lawyers and firm lawyers. What we needed in 1968 when we were formed, which was the same year as the Fair Housing Act was passed, it's a few years after the 1964 Civil Rights Act. These laws made it illegal for the first time at a federal level to discriminate in housing, public accommodations, and employment. And what we needed was an army of lawyers to come and use these new tools in order to protect the rights of Black and Brown communities in particular, but also other communities. And the committee was formed to leverage the resources of the private bar to provide that legal representation to victims of discrimination and make these new rights a reality for folks. So there was shared leadership and vision between the committee staff, pro bono counsel from the very beginning, and clients are a key part of that vision of shared leadership as they ultimately set the goals for the litigation that we do. In the past several years, and this is reaffirmed in the strategic plan, we've really focused on building community partnerships as well as recognizing those who are in the community as essential to the work that we do. And this really goes to a philosophy that, filing a lawsuit in isolation can produce change. But in my experience, and I think in the experience of folks on staff here, you can be so much more effective when you're proactively engaging the community and the change you're trying to make. And I'll get to our substantive docket in a minute, but a really simple example of this is in our housing work, we do systemic housing conditions cases, so whole building housing conditions cases where we're looking not just at one person's apartment, but at what are the conditions throughout in terms of roaches, rats, mold, water coming in. We only work with organized communities in these buildings. So we will only do a litigation for a building if we have a tenants association that's well set up to facilitate the litigation, to give us access to units, to work with tenants, and we'll be there after the litigation is concluded to make sure that folks are actually enjoying the benefits that we were able to secure in the case. The strategic plan reflects that our primary tool, as I said, and that our principal value add is strategic litigation. Our teams are honed in on 6 key areas: housing, workers' rights, police abuse, education, disability, and prisoners' rights. And most of those areas have been areas of focus for the committee since it was founded. I'm sure all of you are aware that last year the district had a historic spike in violent crime. We've not shied away from talking about that. Each of our core areas of focus are all responsive to public safety and to the public's well-being. And the theory being that if our Black and Brown kids are being effectively educated in public schools, if they have access to fair and safe housing, if their parents can get work and be paid fairly for it, then you don't have a crime crisis. That's our theory of the case, and I think that's been borne out in DC and in other places as well. We're now in the process at the team level, each of the teams I just mentioned, of confirming the team's priorities for the next few years in their respective areas. And I'll give more details in a moment. But in terms of setting those strategic priorities, we consider what do our communities in DC and Maryland and Virginia need, and how can we make the biggest impact to influence those needs. And to understand that, we're in constant dialogue with grassroots organizers and community leaders. We're talking to local tenants associations, as I mentioned, but also local unions and others who are deeply engaged at the ground level, so that we have a sense of what's happening on the ground level. And we're getting an understanding of what issues are most pressing in the communities in which we litigate. We use litigation primarily to address those issues. And so a key question that the strategic plan calls for us to ask is litigation the right tool for this? Or is there some other tool that we can use or that we can refer out for others to work on this problem? We're working with organizers, community organizations to support the litigation and leverage it. And if we are suing in that context, it's often happening where other forms of advocacy haven't closed the gap that we're trying to close. So I'll talk briefly about each of the programs that we're working in, and with a specific emphasis on education, disability, and housing, which are some of our longer standing program areas. We've been focused on, in education, on the intersection of disability and educational access. We've had a number of individual cases in that space, but also several class actions in the past few years. Right now, we are suing the Office of the State Superintendent of Education, OSSE, for its failure to provide reliable transportation to DC special education students. In DC, as many of you know, especially the parents, the fellow parents on the line, there's no regular busing system for schools. So if you're in the typical program for DCPS, you don't have a school bus that will pick you up and take you to school. But special education students are often entitled to transportation to and from school. And that's because, as part of a student's federally mandated individualized education plan, IEP, he or she may need to go to a school that's all the way across town because it has a specific service that that particular student needs, or that student may need special services to be safely transported, a specialized harness or a specialized attendant who's on the bus to attend to that student while they're being transported to and from school. Some of these students are nonverbal. Some of them have severe physical disabilities. All of them, however, are entitled to an individualized education plan under federal law. If transportation is part of your IEP, by law, that transportation has to be safe and it has to be effective. The problem that we were running into, or that our clients are running into, is that the district routinely and consistently fails to provide adequate transportation. One of our students with severe physical and intellectual disabilities requires a specialized safety harness to get to school. We know from the district's own data that he experiences delays of an hour or more 70% of the time. If my kids, I have a 7-year-old and a 4.5-year-old, if they show up to school an hour late more than 5 times, they're probably sending CPS to my house. In addition to that, they're not getting the benefit of the education that we are expecting the system to provide, and they're getting to school in a way that is disruptive to them. These kids in our class are having that experience 3 out of 5 days in many cases. We have another student who's a named plaintiff who, on one occasion, the bus didn't have the required harness, so it just left him at school. His parents were waiting at the drop-off location, and when the bus arrived, the student was not on the bus. The driver didn't know where he was, the school didn't know where he was, and no one had communicated to the parents. Another of our students with disabilities was dropped off at his dead mother's house months after his mother had been deceased, and months after it had been updated in their system, in OSSE's system, that this student was supposed to go to his aunt's house and had been going to his aunt's house. For whatever reason that day, the bus dropped him off at his dead mother's house. The family had no idea where the child was. The child is nonverbal. And so they set off a scramble to find the child. And these are not one-off problems. These are consistent across OSSI's services. And so we have a class action that we filed last March to address that issue. The motion to dismiss has been filed. We've filed the opposition, and it's set to be argued next month. We've also been paying very close attention over the past few years to the intersection of special education and the incarcerated population. Last year, the court here in the district approved our class action settlement in the Charles H. case. That was an IDEA case, which is the federal law that mandates special education. But that case was challenging the district's total failure during COVID to provide special education services to students who were incarcerated at the DC jail. The settlement will provide millions of dollars in compensatory education packages to those students, as well as injunctive relief. It also requires that the provider of that education be switched out to the Maya Angelou Charter School. We're now litigating a follow-on case against the Bureau of Prisons for its failure to provide education to DC prisoners. As many of you will know, because DC doesn't have a set prison, DC prisoners can end up anywhere in the country, and lots of youth who are entitled to special education while incarcerated are falling into a gap where BOP doesn't provide them anything, and they're not actually in the district's custody, so the district is not providing any education either. So we're hoping in that case for a similar result that we got in Charles H., and we're actively litigating that case. I'm actually reviewing the opposition this afternoon to that motion to dismiss. Switching gears quickly to our housing practice, we have historically litigated straight up housing discrimination cases that all of you, I'm sure, are familiar with. Race, disability, family status, that's still very much a part of our practice and will continue to be post-strategic plan. We're particularly focused in that vein on landlords using proxies for race and other statuses to discriminate. So using criminal records, source of income, meaning typically Section 8 vouchers, using eviction records as a basis to exclude people from housing. All of those three areas I mentioned, we have really great local DC laws that limit landlords' ability to use those in nefarious ways. And so we are focused on that area. We frequently work, Rabbi Khan, with the ERC on those types of cases. In the past few years, we've also started bringing systemic housing conditions cases where corporate landlords have allowed buildings to become completely unlivable. Sometimes we find as a strategy to empty the buildings, force people out so that they can recondition the buildings and then flip the apartments or sell the building and turn it into more desirable and more profitable properties. We sued the owners of the Franklin, a building in Northeast DC, last September, right as I started. That building racked with the typical problems that we see in this area: mold, leaking ceilings, broken elevators, rats, mice, roaches. And we're now in discovery in that case and moving forward. Meridian Heights is another building that we're working on, which is about 10 minutes from where I live, in a gentrifying neighborhood where I'm one of the gentrifiers. But it's very similar circumstances to the Franklin. We are using the DC Housing Code and consumer protection laws to go after the landlords there for similar conditions. As I mentioned, in both of those buildings, we're working in concert with very strong tenants associations. That's really key to the model here. Having an active, organized TA is essential to getting a good result that is also a sustainable result. And we find that to be true across areas in these types of cases. We also just filed last Friday a right to organize case in DC. DC is one of the few jurisdictions in the country that actually has a very strong right to organize statute protecting the rights of tenants to organize and fight for their rights. And we find that the right to organize is so important to tenants' ability to advocate for themselves. And we want to build case law in this area. There is currently no case law in this area. We want to build that so that tenants are more empowered to fight for their own rights and don't have to rely on outside advocates as much. We view all of these cases as core to our racial justice mission in housing. The area around, as I mentioned, Meridian Heights is gentrifying. And that's true of many of the buildings where we're seeing these conditions, these horrendous conditions that people are living in. And I'll just briefly touch on some of our other areas of focus. Workers' rights. We've been focused over the past couple of years on two systemic problems in particular in the workers' rights space: wage theft and sexual harassment in the construction industry. Our client population in these areas trends heavily Latino. In the past year, we filed at least 3 collective actions on wage theft and 2 sexual harassment cases dealing with Latino women entering the construction industry, with several other harassment cases either in investigation or in the administrative process at the state level or at the EOC. One of those harassment cases, truly egregious. We had a mother and daughter who were working at the same site. Both were harassed by the same supervisor. He assaulted one of the women and was later convicted criminally. Even so, rather than take action against the supervisor, management transferred one of the women off-site to a different site hours away that she couldn't feasibly go to, and they terminated the other woman. And we recently were able to resolve that case, but really just terrible, egregious things that are happening as more and more women are entering that industry, which is traditionally very male. We also are continuing to field workers' rights clinics. We went to doing them sessions in person. We're also doing virtual sessions, and we hope to do more in-person sessions in the future. But that is an important resource that workers have access to in order to get brief services and get legal advice. And sometimes even that can feed our litigation as well. In the criminal legal space, we're continuing to fight against police abuse and pretrial abuses in the district system and also in surrounding areas. We had with Mayor Brown, as was mentioned earlier, a significant victory in a Harford County case last year, and we're continuing to fight that fight. We're also challenging conditions in our prisoners' rights space. We're challenging conditions at federal prisons where DC prisoners are housed and at the DC jail. These are class actions alleging system-wide failures to provide medication or mental health services or outright guard on prisoner abuses at USB Thompson, at the DYRS, which is the Department of Youth Services facilities here in DC, where we're dealing with guard on youth assault there as well. So we're continuing firing on all cylinders in all of these areas with a renewed focus on racial justice and equity.
So thank you so much, Ryan. And, Ryan just finished his year 1 mark as legal director for the Washington Lawyers Committee. And it's really incredible to see the team that he is assembling and now leading as we continue to strive for racial equity and justice across the DMV. There are a few questions in the chat, Ryan, if you have a chance to look at them. I'm going to move into the next section to talk about the 2024 strategic plan and how it's different from prior plans.
Before you, well, since you took a breath, can I just interrupt for 1 second? I neglected to mention an important component of PDS's, the Washington Lawyers Committee's history. We did some police misconduct early on, but more importantly, we had a big immigration practice. And that was a long-term project that we worked on and did a lot of good and accomplished a lot and was important to the community. So thank you. Sorry to interrupt.
Yes, no, thank you, Avis. I appreciate your, and actually, once upon a time in 1978, it was then called the Alien Registration Project that was established at the Washington Lawyers Committee and was in place until 1999. Later, that spun off into an independent nonprofit known as the Capital Area Immigrants' Rights Coalition, which is the leading DC immigration nonprofit providing representation to detained immigrants across the DMV. And that organization has recently been renamed Amica and continues to be a close partner of ours. So what I wanted to just highlight is what makes the 2024 strategic plan different from 2016. As Ryan mentioned, in terms of the substantive program areas, we have basically reaffirmed our commitment to racial equity and justice, partnering with low-income communities of color. But the 2024 plan is really an operations implementation plan of the vision that was originally adopted in 2016. And Avis already alluded to this in her earlier remarks. But there are two major components that are new for the Washington Lawyers Committee. First of all, we have introduced a financial model which is a novel idea for some nonprofits. But as I've said to our colleagues, our staff, is that nonprofit does not mean non-financial. And among other things, our financial model affirms several key tenets, including a culture of shared responsibility for the financial welfare of the organization, encompassing board leadership, staff, donors, and others. Secondly, diversifying our funding sources beyond the DC private law firm bar. Third, securing meaningful foundation support targeting multi-year funding commitments. Fourth, expanding our outreach to potential supporters and donors beyond the DC legal community. And five, prioritizing litigation that is likely to generate attorney's fees. In addition, we have also adopted a decision-making rubric that Ryan and his team will consider when they're deciding which investigations to bring, which lawsuits to file. And I won't go into the details here, but some of the key components or key factors for consideration under this rubric include the public importance of the matter, the resources required to litigate or pursue an investigation, 3, the projected duration of the matter, 4, the likelihood of success in the case, and 5, the availability of attorney's fees. So that's just kind of in a snapshot what is been newly adopted through our strategic plan. And we are in the process of operationalizing that going forward. 3 to 5 years from now, in terms of how do we measure success, we are looking to an organization with diversified revenue streams, a financially stable organization. We're looking to generate more revenue through a wider diversity of sources. At the same time, we're looking to reduce our reliance on attorneys' fees for program support. And finally, we're looking to provide incremental growth through incremental revenue enhancement. So that's kind of in broad strokes where the strategic plan landed. I see that that's generated some questions here. So why don't we go ahead and turn to questions? Let's see, I'll start with Misty. Misty, can you come off mute?
Sorry about that. So obviously funding stability, I mean, that just makes sense from keeping everything moving. But how do you balance, when I was hearing that criteria, and obviously we think a lot about project selection, we don't do case selection, but like project selection in a comparable way. What was the discussion in this process for conversations about equity or sort of impacted community input on project selection? Because those factors are pretty, like they're really pragmatic and also really different than the urgency with which potential clients might feel about a matter, or the race equity or disparity of taking cases that might be more likely to be those things, but others, because we certainly weigh whatever impacted community participation is on our decision making in that regard, in those rubrics, and also all those pragmatics of being able to have impact and success and do the work because you have to pay the salaries. So I'm just curious how that showed up in those conversations of that rubric.
Yeah, I mean, you're asking the hardest question. So I'm going to punt to Ryan.
Yeah. No, I think the community input is super important. And it's one of the reasons that we really try to maintain and build relationships with folks, as I said, doing the grassroots work, because we fully recognize that we are not in the grassroots. We're in the, we're part of the DC community, but we're not on the ground level most of the time. And so in terms of, obviously in a case, and it's a little bit different from projects, like if it's a case and we have a particular set of clients, especially if it's not a class case, we have to be guided ethically by what the client wants. But that's different from what our priorities are. So housing conditions, for example, we came to that as a priority area through being in talking to communities and talking to folks about what was going on. We traditionally had only done discrimination work. And what we were finding when we were engaging with folks, people were telling us, that's all well and good, but what about the fact that there's roaches crawling on my kid at night? Or my ceiling has had water coming through it for the past month. Like, where can I go for that? And so we were hearing a lot of that feedback. And so that I wasn't here when that decision was made to shift into housing conditions, but that's how that organically arose as a priority. So I think we can have the issues that we're focused on, but they need to be informed by what we're hearing are the needs of the community. And it was also true that no one else was doing that work. No one else was doing in that space other than the Office of the Attorney General. There's no other organization that is doing systemic whole building conditions work on a regular, consistent basis.
Yeah. So the idea is that the sort of community level input is coming in the prioritization setting, but then when it's case and matter selecting, it has to be those, to some degree, more nuts and bolts litigation strategy, funding strategy. And those are sort of in-house decisions when it comes to case selection, but priorities were set with those. Am I capturing that kind of correctly? Because I think we just struggle with thinking similarly.
Yeah, I think more or less. I mean, on some level, when we're engaging with deciding to represent a client, we're talking to them about what we're about and what, the need for the public good. And is that something you're on board with? And so most of the time, we're lining up clients who have our goals. But at the end of the day, for example, and this hasn't happened since I've been here, but it's happened in my career, in the course of my career, if the client is offered a certain amount of money and decides we want to forego the injunctive relief we were seeking and take this offer on the table, that would constrain us ethically in terms of what our next move was. But generally speaking, we're trying to set our priorities based on what community needs are, based on what our abilities and expertise is. And then when we're actually doing the day-to-day litigation of cases, to some degree, it falls to individual clients. If it's a class case, that's a little bit different, where we have a lot more control as class counsel over what we're moving towards. And in trying to determine what the goals are in those cases, we're talking to the folks who are doing that work in the advocacy community. We're talking to community organizations about what will actually fix this problem. We're talking to impacted people, for example, in the Aussie case or in any of our prison litigation cases.
You're muted too now, Joanne. You pulled a me.
Sorry about that, folks. Ryan, I don't know if you've had a chance to look at some of the other written questions in the chat.
I see Rabbi Khan's first question. If people feel they're being discriminated against in housing, what's the process? So we still have our intake lines open. We have an email account where folks can get in touch with us, and people do reach out to us. And most of our cases, however, don't come from direct intakes. That most of our cases are coming either from tenants associations who've heard about the work we're doing and they're reaching out directly to us, to an attorney on the team, or from legal aid, or from another organization in community who's bringing cases to us. But folks are still able to get in touch with us through our website, by calling the office, or by emailing us. That's the typical way. And Rabbi Khan, on your second question about the ERC verifying that they're complying in past cases, that I'm less familiar with. I'd have to talk to the leadership over at ERC about what their monitoring practices are, and with older cases.
So I'm just going to say, jump in for a moment because I know there's some other questions in the chat, and Melissa Nussbaum has not yet had a chance to speak, so I want to be sure we give her some time. Karen Grisey asked about the school partnerships program, and so this is one of those programs that is being impacted by the strategic plan. So Kent Withicum, who's the longtime education justice advisor, he actually left the Washington Lawyers Committee just a few weeks ago and has joined Georgetown as an adjunct in the street law practicum. So very much continuing the same line of work. We're thrilled for him in this great opportunity. And we just celebrated him and his 12 years of service last week. So in August, he notified all the law firms with school partnerships of his plans, and all existing law firm school partnerships will continue, but there will no longer be any WLC staffing. And so what that means is that there won't be any WLC staff to initiate or create new school partnerships, but the existing current programs will continue. The existing current partnerships will continue. And we will not be rehiring for this role. So I'm going to now turn it over to Melissa Nussbaum, our development director. Thank you, Melissa.
Thank you, Joanne, and thank you to everyone for joining us today. It's been a really interesting conversation. And so there are different ways to get involved with the Washington Lawyers Committee. Of course, when we were talking about our business model, we rely heavily on donations. So I have put in the chat the link to donate to us. Every dollar matters, and we really appreciate your support. There are other ways to also get involved. If you're working for a law firm, we are always looking for partners to litigate cases on. Also to, kind of work with us on some of the campaigns that we do throughout the year with associates and with our event at Branton, our signature luncheon every year. And then there's also opportunities to volunteer. You don't have to be a lawyer. We have people who help us with our workers' rights clinic. And we have information on our website on how to do that. And lastly, I would say, what we're trying to do as well with our business model is we're trying to spread the word about the work that we do. We know that within certain legal communities, people know us, they know us well. That's fantastic, but we need to get our word out way more. So we ask if you would please follow us on social media and share that with your networks. Because that will really help us in the long run in terms of creating a sustainable model for Washington Lawyers Committee. So that's all I have. Just really a huge thank you. Thank you to the Meyer Foundation again for the funding for this incredible work that's been done. We really couldn't have done it without you. And thanks to everyone for all of your interest. We so appreciate it.
Yeah, thank you so much, Melissa. And I guess my final comment about the strategic planning process, it was an intensive process, about 6 months from beginning to end. It involved a large swath of stakeholders. As Avis mentioned, there were some 18 community partners and clients who were interviewed by the Raven team, who were the consultants that we retained, thanks to the generous support of the Meyer Foundation. We had some 40 board members who were actively involved through focus groups. All Washington Lawyers Committee staff were invited to provide input. There were 6 different working groups that contributed to different components of the strategic plan. So I'm very proud of the output. But beyond that, the process itself of going through the strategic planning actually became a vehicle for building and strengthening the organization's culture and community. And this was particularly important since so many people, like myself, were brand new to the Washington Lawyers Committee. We were still emerging post-pandemic, where we had board members who have never met each other, even though they had served on the board for several years together. And of course, the external climate has changed. And we wanted to make sure that the plan of the Washington Lawyers Committee is salient and current and is refreshed to meet the racial justice challenges of 2024 and beyond. So I am grateful for the Meyer Foundation support, and I truly believe that the culture and community of the Washington Lawyers Committee has been strengthened through this process. So I'm a big believer in strategic planning, and I've learned a tremendous amount going through it. So with that, I want to thank all of you for joining us. We're happy to continue any of these conversations offline. Hopefully you all know how to reach us individually. And thank you again for your support, your contributions to the Washington Lawyers Committee. Have a wonderful afternoon, everyone.